So let's begin. Family wealth transfer is not just about getting financial access to the next assets to the next generation. It is also about passing what you think is most important, and also how to avoid damaging our children's relationship with each other after our will is final. I think you would agree, if I leave my money in such a way that my family don't have to pay any taxes through the transfer process, but something happens in the process where it leaves my children uncomfortable and unwilling to be in the same room with each other, I feel that that would be a failure. What kind of ideas and tools would be available to help you so that your family has significantly more success in seeing and transferring your estate in a way that it's harmonious, not only financially, but also between your heirs? So we'll discuss today a few things about steps you can take and also the action items you can bring back home. My name is Larysa Prytula. I'm a certified financial planner and also certified divorce financial analyst, volunteer for Financial Planning Association, and my contact information is on the slide. So first, let's start and talk about three different items or bullet points. First, we need to understand why transfers often fail, why wealth transfer is so difficult to talk about. The second, we'll talk about being familiar with the planning steps you can take to help avoid these commonly costly mistakes. And then lastly, knowing how you can communicate your plan and your wishes with your family to reduce the likelihood that they will be making mistakes that will cause them relationship. So first, let's address understanding why the failure happens. So there's two big components to it, or two big participants in the plan. It's the parents usually and the heirs. So parents often fail because they just don't have a plan. They don't take time to fully consider who they want to give the money to, who needs the money, what needs to be provided, and they also don't take time to consider how they want the loved ones to use what is passed on to them. So that's number one, just no plan. No plan, no time spent on it. It's an uncomfortable topic. I don't want to think about it. I will live forever. And second part to it is they don't communicate the plan. The plan is there and it's been done 5-10 years ago. You barely maybe even know where it is, where to find your estate folder, and you don't communicate what's most important in that plan to your children. So when they receive that document, either they're surprised or they don't know where to start, or they're completely frustrated with the process, and it leaves them very uncomfortable to go through it. So even though many who do have a plan fail to communicate their plans to the loved ones before the time comes, and there is no discussions between individuals and the family members. Other part of this process is, of course, the heirs. They fight each other after mom and dad passes. Personal stories, past, different opinions. Things start to bubble up, and everybody has their opinion about it, and nobody can agree. So not only they fight each other, sometimes they do fight the plan. When they fight the plan, they basically trying to interpret what the mom and dad wanted to have, because they just have a document in front of them. There is really nothing they can take more than just the document. There was never discussion about it. So they fight the plan. They often the case, because if you never talked about your estate plan with your kids, even on a general level, then they will try to interpret it themselves the way they believe it's correct. And if there is a 3 or 4 or 5 kids in the family, it becomes even more complicated. It is also often happens that they just don't know what's coming, and they caught by surprise. They also either don't, another reason for failure is they either don't accept the advice given to them by an estate attorney, financial advisor, or tax professional, or they don't accept an advice. Many heirs don't seek or accept advice from their parents or their parents' advisor, and they end up making very costly mistakes. One example is distribution from IRA. Before talking to a financial professional about what's the tax consequences of it, they just take the money and they realize it's all taxable end of the year. Another example I just recently have, there's the younger family member, the granddaughter inherited some money from the aunt, and without knowing it, she just pulled the distributions out. It was an annuity, later on realizing that all of it is taxable. So we need to be very careful what steps the heirs taking and making sure that there is somebody there to explain it to them. Another reason for failure of the plan is when heirs don't have skill or expertise to manage inheritance. When a big sum of money, fall on your lap, it also comes not only with maybe enjoyment of it, but also responsibility. How are you going to spend it? Where is it going to go? How are you going to protect it? So when you don't have experience managing a big sum of money, you would really need to think about what team you need to assemble around you to help you with that. So this money not only will take care of you and your family, but potentially your own heirs. All right, so let's take a look and see an interesting psychology around this. So comfortable discussion about estate plan is a far-reaching out desire, because people really don't like to talk about it. They would rather talk about religion and anything else. Talking about money is not very comfortable for them. We're not comfortable to disclosing money to our children. But why is that? It's commonly thought that the fear of seeing greed in your children is the number one answer. Number two is you're concerned that they won't strive as hard in life. So we're worried about talking to our children about money and about the inheritance will basically leave them without any interest and desire to earn their own. Or potentially you can start feeling that they really want that money sooner to solve their problems. So my idea about that is you really don't have to be very specific. You can give them an indication, but it's very important for you to start the conversation sooner. And we'll talk about the conversation and how it should be going. Let's look at these statistics, very interesting. So how many family wealth management, how many families talk to their wealth manager about their estate plan? 41%. And those who talked, they felt that was very, very helpful to reiterate that idea to a next generation. The reason for that is because your estate planning attorney, your financial advisor, your financial planner, all of these people are not materially interested in the end result, meaning they're not, they don't have a skin in the game to make any negative impact on the decision. So they're just facilitators of the discussion. And they can be very unbiased and very professional mediators between you and heirs. I've done it many times when my client wanted to do certain things. Let's say he wanted to sell the house because he wants to give money to kids sooner, and he doesn't want kids to deal with house selling later on down the line for a number of reasons. And it's difficult for her to communicate these decisions to both sons, because she felt like one potentially might still want to continue staying in the house. He was still living in the house with her. Another is out of the house. So one might have an easier way to accept the decision, and others feel like he would be kicked out of the house. So we created a plan where we decided how we will present an idea and how we can also make sure that the other child who lives in the house can have his own place. So there is always a better way to handle those estate decisions with somebody who is familiar with the subject. Financial advisors come across that all the time. Estate attorneys do that all the time. So it's good to have that advice and idea about how do I handle this? How do I make sure when I bring that information to my kids, they're okay with that and they know why? So we use a lot of facilitation and mediation in those discussions, and they really, the kids especially, really benefit from it. We have a perception that the family wealth decisions are all about trusts, tax distributions, tax strategy, insurance policy. But in reality, not just those tools that are available to your financial advisor might be helpful, but also very important is achieving your family wealth goals. How much do you want to leave behind? Is there any charity? Is there somebody who is really dear to you would like to leave the money to? So those discussions can be very well facilitated with those who are familiar with the subject. That could be your financial advisor, it could be maybe even your family member, but it's extremely important to do. A real purpose of the family wealth conversation is to impact your heirs' decisions on that inheritance later on. If you very strongly don't want these assets to be used on particular causes, and you would like to express your wishes that maybe you don't want to put it in the paper to make it too restrictive, you need to start communicating that with your kids. And the chart on the left illustrates what investors will do with inheritance. 36% would probably move it under their own investment advice, and they probably will move it into their own investment company. So very few leave it where the parents usually keep the money. Most of the time, the exchange of the funds happens pretty quick. Chart on the right illustrates the reason of moving the inheritance to different firms. So you can see that they have an advisor relationship elsewhere else, they're happy with, or better investment options. So it's definitely the generation transfer happens on the many levels, including changing the companies. All right. Now let's give an example. One simple, simple example. As this is on your left, you can see it's your family cabin on the lake that the whole family was growing up with. Not only kids, grandkids now come to visit, and you have 4 kids. So now one child lives 1 hour away, another child lives 2 hours away, and the 2 others live out of state. And you decide to leave the cabin for kids to use after you pass. But unfortunately, not all of them get an equal share of using the property because some of them just not in the area. So you need to be very careful what kind of decisions you're making in your trust document that do not create any sort of commotion within your family. So far what we've covered here is why the transfers usually fail, what decisions needs to be made. Now, let's talk about the logistics of it. What would be the best way to approach it? Here on the screen, you can see that you can create a simple family financial map, and the map will say your names, and then you will put all the people that would matter to you. Maybe your parents that might need care, maybe somebody who has a special needs, your children, and each child can also have a very, very different needs. One child may be already finishing up their doctorate degree and they already have job lined up. Another child might be just starting out the career. So you need to consider where each person that you love and you care for is in their life. Your older parents might need special care. Maybe you have a family member that has special needs. The special needs is completely different planning required, because special needs kids or family members, they might need an executor, they might need somebody who will manage the money on their behalf and provide for their wealth and welfare. So we need to be very strategic about that, and then we need to think about every person individually and very deeply, because it's not only the money available, but also what kind of care and who will be involved in making those decisions down the road. So this family map is a very good tool to start the planning, and also to review your existing trust. Even if you have an existing trust, sometimes people confuse what's written in the trust. And then when you start mapping out what matters to you today, then you can align your current goals with the ones that you already have created maybe 10 years ago in your trust document. You can need to consider if it's children from the current marriage, children from previous marriages. The approach is very different. Children who are doing well versus the children that need a little bit more help. So all of those things can go on the map, and then you can try to match it with your trust documents. Next, use your family map to have a planning conversation with your attorneys, tax professionals, financial advisors. Start or review your current plan to see how well it matches what it matters to you today. This routine review and update of this map will ensure that your trust document is always up to date with your current wishes. Some of the documents or steps you will want to review to create this plan is the wills, the trust, the durable power of attorney, so just power of attorneys, beneficiary designations from your IRA. It happens all the time. We forgot to name the right beneficiaries, and then by California law, whoever is listed on the IRA beneficiary, if the person passes, goes to that person, no questions asked. Any IRA beneficiary designation supersede any trust document, so it's extremely important for you to review the trust beneficiaries. I do it every year with clients, even though the ideas might not change, but sometimes we say, oh, wait a minute, what if we include this person in a trust? Or then what about this family member? Maybe they should take the IRA instead. So the designation of the beneficiary is important because it's related to mostly retirement accounts, but it's also part of overall planning. Then we can decide what's the best way to allocate the funds and pay least taxes. I'll give you one example. There's two children in a family. One is still a student, another one, there's a big gap between the kids. One child is already 35, well established, a doctor. Another child is just got out of college and pursuing master's degree. So and we know that down the road, and he wants to be an artist, the second child. The first child is already making a good amount of money, and we're deciding how do we split the assets. Well, currently, what's important is to understand that the one who is making the most money will benefit from the accounts that have already been taxed, like your trust account, individual brokerage accounts. Where the younger one, because he doesn't pay as much taxes and might not pay taxes in the next 10 years, maybe IRA beneficiary for him would be better because he will take the money out of IRA, pay very little tax. So the money goes a long way. And 10 years down the road, the one who wanted to be an artist became a very famous musician and brought his estate to the very, very high level very quickly. So now we need to rethink, is that still the good strategy tax-wise? How the kids now, how do we split it to not to pay too much money to IRS? And how do we make sure that the money also lasts a while for kids? So there is a lot of considerations. That's always moving target. The map that you're creating, it will be a guide, not only to you, but also to those who will be settling your estate. Because you write in that map something that maybe you wouldn't write otherwise in a trust document, which is mostly a legal document. Also think about the letter of guidance or instructions you can create. Sometimes we call it a love letter, where you can address every single individual that you're thinking about, and you will specify, especially to those who are your executor in the trust, how you would like it to be handled, where all of your advisor's information is, what needs to be done first, what needs to be done second, how things need to be handled. The more details and guidance you will leave, the better it will be for your heirs to execute the estate. Lastly, engage and educate your family members. Tell them about it. You're planning to open an account for them, so you will establish a 529 plan. Tell them what you're planning to do. Tell them what the amounts of money you consider into deposits. Engage them in this conversation. If you're opening a new account, maybe bring them into your financial advisor or tax professional office and introduce them and tell them that's what's planning to be done, and this money will be for them. So have a discussion about their personal objectives. It will help you not only to be very clear what you're doing for them, but also for children to be encouraged to take care of this money while they're changing hands. If you're establishing a 529 plan, explain to them, or let your advisor explain to them how a 529 plan works. A lot of people don't know that it's in your rule passed that now remaining of the 529 plan balance can be, given certain circumstances, rolled into the Roth IRA for beneficiaries. So it's a great way for you to disperse the money without paying taxes. So you need to be always talking to those that you're giving gifts to. They understand the reason why and how the money needs to be handled. Sometimes parents want to give the money, but they're worried about the kids will spend or something, they will use on something that they're not supposed to. If we give money to minors, somebody else can make a decision on their behalf. But once those minors become 18, they can make those decisions. If they want to go and buy a Maserati with that money you've been saving for them for 10 years, they absolutely can do it. And the financial advisor cannot stop them. So education starts early. You start to engage them in the conversation, talking about what the mom and dad wanted with the money. I have those conversations all the time. When I open a brokerage account and I put $16,000 excluded amount from tax, gift tax, and I always tell the kids, I say, this is the expectations that your mom and dad have about this money. They really want to have you a house, maybe 5-10 years down the road. That's why they establish in this account. So when you're ready, you'll have a down payment. Let's talk about the investing. What makes sense? How do you invest your money? So we're starting conversation about the wealth generation already for the heirs, not even for parents anymore. The great way for them to get into this on an easy way and not to worry about, the parents' control. Educate for tomorrow. So make sure your children have easy access to the list of names and numbers of all of your legal, tax, insurance, employer, financial contacts. Make sure your loved ones know how to avoid mistakes when the time comes. Mistakes can include the tax, mistakes in inheritance or retirement assets naming. It also could be something that you want to make sure they don't spend the money quickly because of maybe previous histories. So you try to educate them while you're around as much as possible by yourself, or even better yet, with that team that you surrounded yourself with of financial professionals, insurance professionals, and estate planners. Engage and educate continues in the way of maybe writing a very soft, not a legal document. But remember, in state of California, anything written by hand considered an official document. So whatever you say there can be easily executed. So you can write a letter stating and addressing everybody, and maybe making sure that you be very personal to each person in that love letter. You tell them about what you would like to see happens. Maybe you tell them how proud you are of them, how much money this can help them do what they really want to do. You tell them about the responsibilities that money brings. In a few sentences, you can create a very big connection between those that's left after you're gone, and they would probably cherish it very much because it would be your last message to them. So I think it's very important to consider this kind of document. A lot of people postpone writing it. It's not easy, but I encourage you to start very small, and then you will see how beneficial it will be for your kids down the road. Most powerful part in all this process is that coaches parents how to write an ethical will, letting your kids understand why you made this decision or that. This love letter exactly for that, because the trust document is a very dry document. It doesn't really say why you're doing this and that, but this letter can really be beneficial for you to share with them either now or later. Sometimes people fight about silly things like, what kind of personal valuables they want to have. And if you don't have special designation for each item, like maybe a piece of art or carpet or some family, china, then you might want to, when you have time to sit down with them, ask them, to draw out of the hat numbers, and then each number will represent a different piece. And then you see if the children really like what they got, and start to have a conversation. Who would really want to have that a piece of china? Who maybe want to have the family, motorcycle? So that would be nice to have that exercise around the family time, maybe Thanksgiving, Christmas, when you try to get an indication who wants what, and match that with the kid's desire instead of making an assumption of how you want it to be distributed. A lot of good resources out there available for you to read and follow. You can definitely look at these couple of books that are help you make those decisions, also help you communicate those decisions to your kids in a very loving manner, so everybody feels they've been taken care of. So those are a few books, and we'll make this available to everybody, so you don't need to write it down. We'll make the slides available to you. And all of these books basically have one thing in common. They want to make sure that whatever comes after you is how you envision it, and also creating a bond in a family instead of tearing them apart. So I think that's very important, because what you want to leave is not only the legacy and a good memory, you want to leave something that can be multiplied and made better many times. If that's an asset that potentially, whole family can benefit and they can do a lot with that, it will be a huge continuation of your will and of your legacy many generations down the road. So it's really important to think about it on a long-term basis. All right, so a couple more thoughts around this. When we talk about inheritance, we often talk about wealth transfer to children. However, there's many more ways to transfer your wealth, not only to kids, because many of us have interests. We have cultural, educational, social programs we're really interested in. And I would encourage you to share that with your kids. See if your kids are interested, or even learn about what kind of causes are interesting to your children. And you can make those organizations, if they're dear to your heart as well, as a part of your estate plan. So you're involving your children's maybe charity or the environmental inclinations, and be making it part of your trust, of your will, if that's something you would like to do. So instead of giving children money outright, maybe you can contribute some funds into the organization or the causes that's very dear to your children. So this is big, because we know that a lot of families understand that, the charity starts at home, means you need to give the money to the children first to be self-sufficient and thrive. But nevertheless, there is other ways to give, and through local and global charities, there are a lot of organizations that I'm sure you would be interested to consider, and give them a thought, and think about percentage, what kind of asset can go there. A lot of times retirement accounts is one of the best way to pass it to charities, because when charitable organizations receive retirement assets, they don't pay tax on it. Or if your family member receives that, they would owe tax to IRS on every dollar they take out of pre-tax IRA, not the Roth, but IRA will be fully taxable to them. There is a new rule I want to tell you real quick about the IRAs that passed 2 years ago. We used to be able to stretch all your IRA beneficiary, all beneficiary IRAs over the beneficiary lifetime, but not anymore. They limited us to 10 years maximum. So you can pull all the money from the IRA either the first year, within the first 5 years, or whatever, but you need to finish all the distributions from inherited IRAs, those IRAs that have been inherited 2 years ago. The ones that have been inherited more than 2 years ago, you have an ability to stretch it over your lifetime. But the ones that have been inherited after, you have to pull the money by year 10 and be done and pay all the tax. So a lot of tax strategies and planning needs to be around that. So call for action for everybody. Maybe think about creating a family map. Review your map with an advisors, with you, those that are important to you and whose opinion counts. Create or update your planning documents with what you need and want to accomplish with your family assets and treasures. Then strategize with your advisors how to begin or continue to engage your family. Communicate today, communicate often, and make sure the communication is always positive, is always about love and care, and try to be very fair in your eyes how you treat all the family members. I do see sometimes that the family members are not always treated the same way, because one member is considered more successful than the other, and it does unfortunately create a family distortion, so you need to be careful about that. We came to the last slide, so I would love to hear some questions. Maybe we have some information via chat, so we can take a look. Let me see. So I'm not seeing.
If anybody has a question, please feel free to enter it in the chat box. In the meantime, I have a question, Larysa.
Sure.
Do you have a sample of a family love letter?
Sample of, I can look into that.
Okay.
I can definitely look into that and get back to you. Yes, it would be nicer to see how it's usually written. I understand. Absolutely. Yes. I'll make a note of it and see if I can find something for you in the next few days.
Okay, thank you.
Mhm. Somebody asked, I have a trust now, but want to revise it. Can I keep the same name? Absolutely. In fact, most of the time, 99% of the time, you would keep the same name. And you would just make a revision and call it an amendment to your existing trust. So name stays the same. Great question. How will 401k be taxed after it's transferred to kids versus IRA? Great question, no difference. The 401k transfer to heirs versus IRA transfer follows absolutely the same process. It's per beneficiary designation, and it's going to be fully taxable for every dollar you take out of 401k. Because both accounts, IRA versus 401ks, are pre-tax, they will tax exactly the same way on the amount that's been taken out. Good questions.
Somebody messaged me asking about covering taxes regarding, I guess, wealth transfer.
Great question, because right now it's a very high exclusion amount for family of husband and wife. It's over $22 million. So 90% or 95% of US population not subject to estate tax currently. But don't get excited, because in 2024, if we do not change the law, it goes back to sunsetting these high amounts. And we go back, if nothing changes, to $6 million. So that the changes will come if no new legislation is passed before 2020, end of 2024. So we have literally like a year and a half left with this high exclusion amounts, and they go back to a pretty low number. I believe they go back to $6 million each. But Congress has been talking about making it $3 million each. So we have no idea what will be happening, which is very difficult to plan. But currently, if anybody passes between now and 2024, unless they change the law next year, then you have a huge exclusion amount. So if your estate is $22 million or less, you pay zero estate tax. And for those who are having a larger estate, then your estate taxes 40% of anything above $22 million. 40% estate tax above any amount over exclusion. So if exclusion goes back down to $6 million each, so if your estate is over 12, for every $1 million that's over that, you would have to write a check to IRS for $400,000.
And that's federal.
That's federal, right? And there's also state taxes. There's also state taxes that very similarly, I think, structured. What if your child lives abroad? Are there any other concerns related to leaving the money or property? Excellent question. So the estate taxes are due on the US assets. So it's regardless of where the heirs would live, you will be still subject to estate tax. As far as the transferring assets to that person, it can become very complicated, because if that person doesn't have a social security number, doesn't have any ties to United States, it's going to be quite difficult for that person to actually get an asset. I have a situation where it was an attorney. He passed away very quickly, but he built a very nice real estate business. He has few real estate properties and also assets. No heirs, no direct heirs, his mother. And his mother lives overseas. And it's very difficult to transition those assets to her, because she has no ties to the United States. So it's extremely difficult. There's petitions going on. It's a case, actually, current case that I've heard of. So if somebody living overseas and they don't have any ties to the United States, you might want to establish them here somewhat, at least to open them a bank account, brokerage account. So when the transfers do need to happen, that person already has something established. Otherwise, it's going to be very, very difficult.
What if the child is a US citizen, but living abroad?
Much easier, because that child is considered US resident. So US resident can go online and with the social security number and everything else, open an account. They can, it's much easier if it's US citizen. US citizens always maintain, they always pay taxes. If you're a US citizen, you pay tax on any income generated across the globe. As a result, it's much easier for you to establish yourself overseas and make certain transfers and transitions by still being a US citizen. You have records here, so it's much easier. US citizen children, I don't think it's a problem as long as they can come here, they can establish the account, they have social security number. It's not a problem. Those who are non-US citizens might be an issue.
There was an earlier question asking if one can transfer money from one's IRA to an IRA for a child and save taxes.
If somebody can transfer money from their IRA to directly to child's IRA and save on taxes?
Yeah, yes.
A good question, but I think there's a little confusion. So if the transfers of the IRA to IRA, because one person passed and another person is survived, these transfers can happen from his to her IRA, from her to his, between spouses. So spouse can have the other spouse's IRA rolled into her own IRA and treat that money as her own. Okay. Where if it's a child, any other heir, anybody, children, nephew, nieces, friends, it doesn't go into your own IRA account, never. It goes to an account called inherited IRA, and those inherited IRA funds need to be depleted and taken out within 10 years. So the new account that will be established with the money that was inherited never goes into your own IRA money. It goes to a special beneficiary IRA. So no taxes can be avoided. Actually, on both sides, it's just a matter of which account you'll be using. Once the person passed away, you roll it, you don't pay taxes on this rollover, but as you start taking money out into your pocket, you'll be paying taxes as you go. But the transfer itself is not taxable event. When it comes from one person to the other, it's no taxation. It's just when you start taking money out, the taxes will be due.
Okay. All right. And then there was another question. If a trust is in place, but without trustees, who's in charge of executing the trust?
Trust in place without the trustees. I've never seen a trust written by a qualified attorney without the trustees. It's usually when you establish the trust, the first trustees are you and your husband, or you and your wife, and then there is a successor trustees. If you're not around or you're not in capacity, then someone else will step into it. So I've never seen a trust without trustee. Is it up to beneficiaries to work amongst themselves to do the necessary paperwork and legal work? It is up to beneficiaries. Well, it's not up to beneficiaries. You have to hire somebody to administer the trust as a trustee. Somebody has to be in charge. Like one thing I didn't mention during the presentation is that it's very important to leave an alpha person in charge of your trust. When I say alpha person, I mean like alpha child, somebody who would take the charge, start doing it. So without the trustees, it's like a car without the steering wheel. You have a car, it can move, but it does not move because you don't have a steering wheel. You have to have a trustees, but if you don't, you might want to add them. And yes, beneficiaries will work with the legal system to, distribute assets.
Okay, and then I got a question. How is inheritance from a foreign country from parents living abroad handled if you're in the United States?
I see. Let me see. Is that written down?
It was direct message to me.
Direct message to you. So if the parents live in abroad, how does this work? So it depends if the parents are US citizens or not. If the parents are US citizens, it's pretty easy because if they have assets. So if the parents have assets here, everything goes by the law of United States and they're US citizens. It's a really matter of the US citizens or not. When I say US citizens, I also mean green card holders. If they're not US citizen or not green card holders and they live overseas full time, then when they pass, it will be matter of do they have assets here? If they do, they better have a good trust, because non-US citizens or non-green card holders, they do not have that $22 million exclusion we were talking about. They have only, I believe, 150,000. And then after that is everything is state tax. So you need to be very careful if you have a family member who is not a US citizen, the estate planning becomes extremely complex. And you need to talk to a state attorney. So it depends if they're US citizen or not. If they're non-US citizen, it's a problem, because then you would need to really work through different, like Q-tips, if you heard of that, provisions, different type of trust to make sure there is no estate taxes due. So you need to talk to a state attorney. It's a very complicated.
And that's for assets held in the United States.
Even for assets held in the United States. For assets held outside of the United States, it's assets out. I don't believe if you're non-US citizens, US has anything to do with that. But you need to talk to a state attorney about that.
Okay. And I have another direct message question. How do you decide if a person has capacity as a trustee?
A capacity meaning still able to make the decisions and their cognitive decisions.
Right.
So there's a process. If you start seeing that the parent is not coherent and cannot make decisions, they forget things, or they don't write checks on time, and you can see the deterioration mentally, then you would need to get a letter from a doctor, from that parent doctor, to state that they're not, they're cognitively impaired. And if the doctor states that, then successor trustee who will step into their role will manage the assets. So that person will, and then the trust will specify what happens if mom or dad not coherent anymore. Then you need to get a letter from the doctor, from the family doctor who knows the person, that they are not able and not in capacity anymore. Then everything, that decisions, all the decisions goes to a successor trustee, which could be either another other parent, or usually it's the other parent, or if not, let's say it's only mom around, then it could be the second trustee. We call them successor trustee. But you need the letter from the doctor. You can't just decide it on your own.
Okay, thank you. I don't have any other questions.
Okay, all right, great. Well, if somebody thinks of anything else, I can happy to answer. Also, please keep in mind, I am not an estate attorney, because we had a lot of questions that actually covering an estate attorney reality. So I am very broad in general, but anything specific, like a lot of people asking about foreign assets, inheritance from parents abroad, US citizen or not. Definitely, those are very complicated situations. So it's better to be addressed and discussed with the state attorneys. I know enough to be dangerous, but I don't want to give you a wrong advice. So anybody, any inheritance from parents abroad to US citizens in the US, discuss with your state attorneys. Usually, I don't believe it's a subject to estate taxes. It's a gift to you, but you need to talk to a legal counsel about that. All right?
Thank you.
So, thank you.
Asked if we'll have access to the PowerPoint slides. Yes, Stephen. Larysa will make them available, and I will email them to everyone who registered.
Yes, yes, wonderful. Wonderful. Thank you, everybody, for joining us today. I appreciate. Thank you, Lisa, for facilitating. It was great to get all the questions. I hope you found it interesting. I will look for love letter and maybe any other supporting documents I can provide.
Thank you so much, Larysa.
Thank you. Have a good one. Bye-bye.
All right.
Bye.
Bye.